Good morning. My name is Len Foy, and I am a real estate attorney in Nashua, New Hampshire. I am the president and the managing attorney of Foy Law Office, PLLC. And again, our office is located in Nashua, New Hampshire. I'm also the president of Sunset Settlement Company, LLC. Together, Foy Law Office and Sunset Settlement Company handle real estate closings in 4 New England states: New Hampshire, Massachusetts, Maine, and Rhode Island. This is the next installment of an ongoing series of video productions in which I have discussed our services, the services that we offer, which are closing services, title searches, deed preparation, settlement services, also known as. So in a nutshell, my office handles real estate closings in both residential and commercial real estate transactions in the states that I've identified. And again, I'm the host, if you will. And again, my name is Len Foy. And I would like to speak for a few minutes this morning about deeds. And this is a subject, of course, that we've covered in other video segments. But I think that we've got a great number of people in the real estate marketplace who perhaps don't fully understand deeds and how deeds are drafted and how they're utilized and recorded and their meaning. And then I think you probably have other people who perhaps have an understanding of deeds, but who underestimate their importance, the importance of making sure that they're accurate and free of errors and mistakes. So with this contingent of people who either perhaps misunderstand the importance of deeds or perhaps don't have maybe a solid understanding of them at all, I think it's imperative upon me to try to go over this subject once again. And I'm going to try to be as brief as possible. I think sometimes I have, I make the mistake of talking too much, and so the video becomes too lengthy, too anecdotal perhaps, and maybe viewership drops off a bit. So I'm going to try to keep it as concise as possible and as tight and informative as possible so that people can derive the maximum benefit from watching this video. I hope that the video is somewhere between 5 and 10 minutes in length. So without any further ado, my name is Len Foy, and I'm a practicing attorney again in Nashua, New Hampshire. I've been practicing law for just about 20 years. I've got a 20-year anniversary coming up in February of this year. And in all that time, I have been handling real estate matters, both commercial and residential. Since approximately 2002, I would say that my practice has consisted almost entirely of real estate matters. So that has gone from being one of several of my practice areas to really being the concentration and focus of my law practice. With respect to deeds, I'm going to try to touch on what I consider to be the most salient and most fundamentally important aspects of these mysterious legal documents, in the hopes that by the time you are done watching this video, you may have a greater understanding of them. So, first of all, just to begin at the beginning, which I think fairly would be, what is a deed? And the answer to that question is that a deed is a legal document wherein the ownership of property is conveyed from one person to another, or from one entity to another, or of course you can mix and match from a person to an entity or vice versa. So that is basically, that becomes our starting point. Deeds must be in writing, so it's really impossible to convey ownership in real estate verbally or through any other means other than in written form. So a deed will always be a document, and it will typically consist of a title, which we'll talk about. We'll get into all of the constituent pieces of this document, but it will have a title, it will have the parties, which are the people or the entities involved, it will have a description of the property being conveyed, it will be signed by the person or the appropriate person at the entity that is conveying the property. Under some circumstances, it's signed by the people receiving the property. That's typically in a condominium situation where the buyers or the grantees are being asked to agree to certain conditions and covenants and restrictions, and they want to establish that that agreement occurs basically at the time of transfer by having the buyers or the grantees actually sign off on the deed itself. I don't see it frequently used in other than that context. And then, of course, the document must be notarized. So let's just try to rapidly go through all these pieces. First and foremost, though, I would be remiss, I'd be negligent if I didn't begin this discussion by encouraging people in the strongest terms possible to consult with an attorney if you are having a deed prepared, or if, heaven forbid, you are preparing your own deed. I don't advise it. And I think many a real estate fiasco was born of people attempting to prepare and record a deed independently and without the advice of an attorney. So please, 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 if you are contemplating the transfer of real estate, or you are involved in a real estate transaction and you would like an attorney's assistance, either preparing your deed or reviewing your deed, telephone my office and I'll make sure to provide you with some contact information at the conclusion of this video. So again, importantly, the deed begins with a title. What are we going to call it? Well, it's typically referred to as a deed. So the question becomes, what kind of deed? And there are many kinds. There are quitclaim deeds, there are warranty deeds, there are fiduciary deeds. So there are unit deeds, which we see periodically used in condominium situations. There are many different examples of deeds, and of course it changes not only from transaction to transaction, but it changes from state to state. In New Hampshire, if you purchase a property, you typically receive what's called a warranty deed. In Massachusetts, you receive a quitclaim deed. And we can talk about that. I mean, we could spend an hour on that subject, we could spend a week on that subject, but the types of deeds utilized harken back to a time when people would qualify the transfer of property by the kind of deed they gave. And warranty deeds were considered to include a more expansive group of representations and promises, whereas quitclaim deeds were viewed as being somewhat more limited, more conditional, and with fewer assurances by the person making the transfer as to what they owned, or perhaps boundaries, or perhaps what was included, whether there were disputes or clouds on the title. We've evolved away from that model almost, not entirely, but almost entirely, with the advent of title insurance and some other things. But it really is a creature of state law. In Massachusetts, quitclaim deeds are utilized across the board, except when there are estates involved, and then of course we have fiduciary deeds. So I would say, obviously, the convention and the customs of your particular state will dictate what kind of a deed you utilize, and I think it's important to call my office with any questions that you might have. But certainly in the two states where we are most active, New Hampshire and Massachusetts, we typically use warranty deeds for purchases, for value. In New Hampshire, we use quitclaim deeds. In Massachusetts, in New Hampshire, we use quitclaim deeds for a different subset of transactions. The most common example would be, say, somebody owned real estate as their individually and decided to add a spouse or a family member to the title with them. They would utilize a quitclaim deed for that purpose. The parties in the deed, we refer to them as grantor, grantee. So the grantor is the person that's conveying the property. The grantee is the person to whom the property is being conveyed. Buyer and seller, to utilize that terminology would really be incomplete, because it would leave out an entire universe of transactions where people are receiving property but they're not paying money. And that could be pursuant to a will, it could be family members transferring real estate amongst each other gratuitously. So there are many examples of people receiving property or transferring property in which no money is changing hands. So buyer and seller only covers a piece of the overall body of transactions that we deal with. So grantor, grantee is more commonly used. The description of the property, there is a description of the property, and it definitely goes further than a physical address. So you would not see a deed limited to the conveyance of, say, 123rd Main Street in any town, USA. It may well include the property address, the 911 address, the physical residential address, or property address, but it probably goes on to include either a lot designation or what we call a meets and bounds description, which would be the actual boundary lines measured off in degrees and feet, so that somebody, if they were of the mind to do it, could actually walk out the parameters of the property involved. Sometimes it's a combination of things. It's a lot reference on a plan or a map, and then in addition a meets and bounds description. The deed needs to be signed by the people who are transferring it, and that deed and that signature upon that deed needs to be notarized. The notary is to assure that the preparation and execution of the document is free of fraud or forgery. So the independent notary, the notary should not be somebody who is connected to the transactions. I see it all the time. Notaries, somebody has the proverbial brother-in-law who's a notary, or sister-in-law who's a notary, and for whatever reason, either out of novelty or for other reasons, that person wants to become involved in the notarization of that document. It's generally improper. The notary should be a disinterested third party. So if you have a family member, across town that happens to be a notary, I've just seen it so many times, and I'm not clear why it happens. I think people, because they're notaries, maybe they don't do a lot of notarizing. It's a way to be involved perhaps in a family event, or to be the notary. But it's really improper to have the notary somebody who is what we call an interested party, and that could be somebody related by blood or marriage to one of the parties involved in the execution of the documents. So it really should be somebody who's a legitimate notary, but somebody that has no connection to the parties involved, so that the performance of their notarization cannot be called into question. The deed needs to meet certain requirements in terms of formatting and ink color and the size of the lettering and font and spacing and margins. So it can't be handwritten. Once upon a time, deeds were handwritten. We have a beautiful deed hanging in our office, a framed deed from the 1800s, a New Hampshire deed, and the penmanship is so it's lovely. There's no other word to describe it, and that's certainly not uncommon. You find that draftsmanship was a big part of was part of the sort of was something that the scriveners of deeds sort of brought to the table, if you will. And if you go back into the registry, into the archives, you will see documents with beautifully written notes and references, and not only the documents themselves, but in the margins and the index. So certainly a good penmanship was once a huge part of the preparation of deeds, but it's gone the way of the dodo bird, so to speak. We're now obviously dealing with typewriters and word processors, so to my knowledge, deeds must still be typed. I believe that a handwritten deed would be rejected if it were submitted for recording. Only original documents can be recorded, so somebody walking into a registry of deeds with a photocopy of a deed will not be successful in having that document recorded. We need original documents only. So that means the actual document with the ink signatures of the parties involved, with a fresh ink notarization, and in most jurisdictions, identifying stamps or seals, so that if it had to be determined who the notary was that notarized the document, that we could do that. It's sort of dovetailing with other lectures that I've given. One of the, I think, great misunderstandings of real estate are people attending real estate closings and they don't know what to read, and so people invariably fall into one of two camps. They either read everything, including documents that they really don't need to read, and that's, of course, to the detriment of all parties concerned, because people are sitting in a conference room literally nodding off while people read documents that, again, it's not necessary for them to read, or they err on the side of reading too little, and they basically just go through and they sign away, which for most of the documents is perfectly acceptable, but in the process of doing so, they overlook a careful review of the documents that I think have to be reviewed. We have other lectures on our sort of short list, if you will, of documents that really must be reviewed, I think, at a closing for you to be conducting yourself in a careful and prudent manner if you are signing legal documents, either as the buyer or the seller. But I think the single most fundamentally important document at a closing is the deed. And not only that, it's the document that is the most custom tailored. So many of the documents in a closing are basically pre-printed legal forms that might only have names and addresses sort of, entered into the document. The deed is a document that somebody prepares from scratch. It may be a paralegal who's quite good and careful and experienced, or it could be somebody in an office with very little real estate experience who is treating the preparation of that document like any typing exercise, where they're just, to the very best of their ability, sort of typing up a document and, you know, hoping that it looks good. If there are misspellings of names, if the correct property is not being transferred, it can create a host of headaches for all parties concerned down the road. It can involve trying to track people down after a closing to have them re-sign documents. If those people cannot be tracked down, it can result in major headaches for all parties concerned. So I don't like to play the role of Chicken Little and try to convince people that the sky is falling, but I think that one of the single most disastrous things that can occur is when a deed does not receive the proper amount of scrutiny at a closing, and it's recorded, and it turns out that somebody's name was misspelled, or somebody was left off the document, or somebody that should have signed it didn't, or that it conveys the wrong property, or that it wasn't properly notarized, and that there's some defect, and it's like a ticking time bomb. When the owner of that property turns around and tries to sell the property or refinance the property down the road, that problem, that defect in their deed will become front and center, and it will be an effective barrier to the transaction going forward until such time as it can be rectified. So it's something that should not be underestimated, and again, please, please, please strongly consider hiring an attorney to prepare your deed, review your deed, attend the closing with you, and I would love nothing more than to perform that role. Other things that I can say about deeds is would be that if names are misspelled in a deed, typically what we have to do going forward is you will be stuck with what's known as an AKA. So if your name is Jones and it was misspelled as Johnson, and again I'm pulling examples out of the air here, then in a subsequent transaction you would be Jones, also known as Johnson. And I think most people would find that to be irritating, especially when it's all the result of a careless mistake on somebody's part and a failure to review a very important document. Neatness counts. Most people who know me know that I am a perfectionist, and I am a perfectionist. And I think most lawyers would do well to be perfectionists. I don't think that's a debatable point, although I know some very sloppy attorneys. And attorneys are like everybody else. We come in all different shapes and sizes. But I don't think it's defensible to be sloppy as an attorney. I think people are paying us for neatness and our attention to detail. A deed is a document that will ultimately be recorded at the Registry of Deeds and will be viewable on the internet by any Tom, Dick, or Harry that wants to look at it. And it never ceases to amaze me when I pull up a deed and it has cross-outs and initials and handwritten changes, and obviously what that signals to me is that the document was not prepared correctly. The incorrect sort of features of it were caught at the closing, which I guess is better than not being caught at the closing, but rather than taking 5 minutes to sort of retype the document to do it right, somebody decided to take the shortcut of making handwritten changes to it at the table. And I think a deed is a reflection not only on the property, but the people that own it. And if I look up a deed, this is especially true, I think, with perhaps a luxury property, and I see it there too. I've seen $1 million properties that were evidenced by 25-cent deeds, and it never ceases to amaze me. But really, I think that it doesn't matter where you're buying or what kind of property you're buying, whether it's the tiniest, most modest property or the biggest mansion imaginable. Your deed should be a reflection of you. It should be done correctly. It should be done neatly. It should be free of cross-outs and handwritten changes. And it should be evidence that you had the right people working on it and not an amateur. So that's my soapbox, and that's my angry tirade for the day. That's about as angry a tirade as you'll get out of me. But at any rate, my name is Len Foy. I'm a real estate attorney in Nashua, New Hampshire. I'm passionate about what I do. I feel very strongly about it. I hope that if you are in the process of buying, selling, or refinancing real estate, that you will reach out to my office. I would love nothing more than to assist you with that transaction. and certainly I would be happy to prepare your deed either for use in perhaps an internal family transaction or as a part of your selling a property, even if you're not using my office for other aspects of that transaction. To contact me, all consultations are free. My phone number is area code 603-598-4030. I'm on the World Wide Web at www.foylawoffice.com. Please send me an email. My email address is lfoy@foylawoffice.com. And if you want to send me a fax, you can do that. I will respond to it as best I can, even by fax if that's requested. My fax number is 603-598-4020. I wanted to send out a thank you to those of you who have contacted me either online or who have telephoned my office, complimenting me on my daughter Natalie Foy, who served as the moderator for a number of our earlier video installments. Natalie will be back by popular demand. At some point I have another daughter, Genevieve Foy, who has expressed an interest in serving as moderator, so I'll probably weave her into our troupe as well. And then I've got two younger children on the way, too young at this point to moderate a video, but certainly waiting in the wings for the future. So again, my name is Len Foy. I'm a real estate attorney in Nashua, New Hampshire. I'm deeply passionate about what I do. I would love to work with you, and I'd be honored to have you as my client. Please reach out to my office for all of your real estate needs in any of the states where we are active. It's January 21st, 2015. I'm starting to lament the fact that winter may nearly be over because I enjoy it. I look forward to it, and I don't feel that I suffer through it in any way. So I feel that the winter is at least half over, perhaps more than half over. It'll be nice for spring to get here, but I'm still hanging on to this winter weather, which I enjoy. Please call my office for a free consultation. Again, I'd be honored to have you as a client. My name is Len Foy. Thank you for watching this video, and have a wonderful day. Bye for now.